This video explains what it is like to go to court without a lawyer. It is based on 2 years of research by a team of academics at Ulster University Law School, working with the Northern Ireland Human Rights Commission and funded by the Nuffield Foundation. The research team spoke to people who go to court without a lawyer, as well as people who work within the court system. These were people involved in court cases in the civil and family courts, but not the criminal courts. This video describes the experiences of the people who took part in this research and may help other people who want to know what it is like to go to court without a lawyer. Most people who go to court use a lawyer, either one they pay for themselves or one who is paid for by the state. But some people do not have a lawyer and represent themselves in court. They are entitled to do this, and it should not impact on their right to a fair trial. For some people, representing themselves may put their right to a fair trial at risk. For example, if their case is extremely complex, or if they are not able to understand and appreciate the consequences of their actions, they may need to have a lawyer appointed to act for them, to protect their right to a fair trial. It can be difficult to know when someone is at risk in this way. There are lots of different reasons why people go to court without a lawyer. The cost of legal representation was one of the most common reasons given by the people who took part in our research. Some felt they would be able to explain their own case to the judge without the help of a lawyer. And some did not have much trust in lawyers to do a good job for them. The reasons why someone is in court without a lawyer should not matter to the judge. She or he is still required to protect the person's right to a fair trial, regardless of why they are representing themselves. Most of the people we spoke to who went to court without a lawyer tried very hard to get some information and support for their case. Most of them did not know where to look and found it difficult to get useful information. They looked on the court service website but found it confusing and difficult to use. And many of the court service documents were not felt to be user-friendly. They often relied on court service staff to provide them with information. Staff were able to help with some of the queries, but were limited in the information they could give to people. Court staff are required to be impartial, which means they are not able to offer advice. This could mean that those asking for help could get frustrated when court staff could not answer their questions. Most people we spoke to thought there would be more help and advice available and were disappointed or frustrated when there was not. Many of those working within the court system also believed there were more sources of help and advice available than there were. This could create difficulties when judges or lawyers suggested that individuals go to advice sources that were not able to help. Going to court usually involves filling in paperwork, and people who did not have lawyers to do this for them could find it difficult. Sometimes this was because the language used in the court forms was not clear or well understood. Sometimes people did not know what the judge needed or wanted to know. This could mean that individuals would not provide the right information. Some people might end up telling the judge every little detail so that the judge could work out what was relevant. This could be frustrating for judges and other lawyers dealing with the case because it meant they had to read through lots of irrelevant information to understand what the person was trying to say. The most common experience of the people we spoke to was that of not knowing. Even though the people we spoke to tried hard to understand the law and procedure relating to their case, they usually ended up being faced with something in court that they didn't know or hadn't prepared for. They did not know how long their cases would take, either on the day of the hearing or overall. They became anxious and frustrated at how slow the court processes could be, including delays on the day as well as from week to week. They did not understand that they could get in touch with the lawyer or the party who was in the case against them as a way of trying to resolve or agree some of the issues. Resolving issues outside of court is what lawyers do all the time. Some of the people we spoke to were worried about getting in touch with the lawyer who represented the other side and were suspicious of them. Some of the lawyers avoided contacting the unrepresented person because they were afraid the person would become emotional and difficult to talk to. This lack of communication between the two sides of the case meant it could be more difficult to resolve the case. Some of the people we spoke to were able to negotiate with the person in the case against them and found this to be a useful way to resolve some of the issues before their court hearing. The people we spoke to often did not know if they could bring someone into court with them, either for moral support or to help with note-taking or speaking to the judge. Different judges had different approaches, which was confusing for some people. When cases involved children, some judges asked everyone other than the parties connected to the case to leave the courtroom. The people we spoke to who were representing themselves found this to be helpful. When judges did not do this, it could be more stressful for the individual to represent themselves in front of other lawyers and experts who were already in court. Many of the judges recognised that it was difficult to go to court without a lawyer and were able to put people at their ease if they did not have a lawyer to speak for them. This might include providing explanations of legal terms or procedures. Often, judges would ask the person direct questions to get the most relevant information. Some judges were less able to put people at ease and conducted the hearing as if the person without a lawyer understood the proceedings. The people we spoke to described lots of different feelings about their experiences. Some felt positive and empowered, but most described feeling frustrated, anxious, fearful, and confused. Some people described feeling supported by those who worked within the court system, but many more described the court system as one that does not accommodate their needs and is not sympathetic to the difficulties they face. Overall, most of the people we spoke to faced a number of barriers in being able to participate effectively in their court proceedings. Some people were better than others at dealing with these barriers, but almost all of the people we spoke to felt that there should be more support for people who go to court without a lawyer. We make 40 different recommendations in our report. Our main recommendation is that reform is needed that takes account of the different perspectives of the people who use the courts and who work in the court system. We think that the information, advice and support for people going to court without a lawyer needs to be much better, and we would like to see an information and advice centre that could help people understand what they are required to do. The people we spoke to told us there are not very many places to go for help and that they find it difficult to get support. People have a right to go to court without a lawyer, but it is important for anyone considering doing this to understand what lies ahead and to decide whether this is the best option for them. Our research reports and recommendations are all freely available on Ulster University's website at www.ulster.ac.uk/litigants in person. We hope you find this information useful.